Hi, I'm kyeong Hwan Kim, a Korean attorney practicing in Seoul. Today, I'll answer some of the most common questions about registering offshore funds in South Korea. Foreign asset managers are increasingly interested in finding potential investors in the Korean market. And on the other hand, Korean institutional investors are also increasingly looking for opportunities abroad. So there's supply and there's demand. But this is not enough. Under Korean law, if you want to market or sell an offshore fund to Korean residents, you should register the fund with the Financial Supervisory Service, or the FSS. The FSS looks into various aspects of the fund and assess if it is fit to be sold to Korean investors. Only after the FSS gives you a formal go sign, which is granting the registration, can you legally sell your fund to Korean investors. So in short, registration is the legal gateway that allows a foreign fund to be offered in Korea. Most of the funds that we register are private funds aimed only at professional investors. While the requirements for those funds are relatively easy to meet compared to public funds, there are still some strict rules to follow. Some of the key requirements include, first, the fund must be properly established under its home country's law, and its documents must not conflict with Korean law or investors' rights. Second, all fees and expenses charged to investors must be clearly disclosed. From my experience, fees are what the FSS is most interested in. So we must clearly explain to the FSS the detailed fee structure, like what kinds of fees there are, how much each fee is, and who bears each fee. Third, the fund manager should not have faced major regulatory sanctions in Korea within the past 3 years. And fourth, the fund should have a proven track record. We generally use Form ADV for this. Fifth, none of the key service providers, such as the manager, trustee, distributor, or administrator, should have been subject to serious penalties like suspension. Meeting these requirements takes detailed documentation and constant back and forth with the FSS. The duration of the process is dependent on multiple factors, like how long it takes for us to prepare the required documents. We have to prepare the application in both Korean and English, and there are a lot of documents that we need to have notarized. There are also some factors that are not entirely within our control, such as the current workload of the FSS. As of now, October 2025, you should expect at least 5 months to complete the process. After all this is done, the FSS issues a formal notification that the fund has been duly registered. Now you can receive investments from Korean institutions. The notification looks like this. Technically, no. There's no legal requirement that you should hire a law firm for this. But in practice, it's very difficult without legal support. The FSS requires both English and Korean versions of the fund documents and application documents. And interpreting the relevant law, which is called Financial Investment Services and Capital Markets Act, is not straightforward. So unless you work with a Korean lawyer who can communicate in English and also understand global fund structure, the process becomes almost impossible to navigate smoothly. In the past, only large law firms handle these cases, but their fees are extremely high. I provide the same level of expertise based on my background at a top-tier firm, but at a much more reasonable cost. So if you're considering registering your fund in Korea, please feel free to reach out to my email. I'm kyeong Hwan Kim, and this was a short guide on offshore fund registration in Korea. Thank you.